The next case on the docket is Jewell versus Gevity HR and Chartise Insurance.
Sir.
Okay.
Thank you, Your Honor. May it please the Court, my name is Bill McCabe and I represent the claimant, Sandra Jewell. I'll reserve 3 minutes for rebuttal. In this case, we contend that there is no competent substantial evidence to support the JCC's finding that the present need for treatment in the form of surgery, as recommended by Dr. Gerber, is the result of a merger of a pre-existing condition and the effects of the accident. And as such, the judge erred in finding the employer carrier is entitled to apportion 40% of claimant's medical care. The statute that applies here is 440.15.5b, 2007. And it provides that if a claimant's need for medical care is the result of either an aggravation or acceleration of a pre-existing condition, or the result of a merger with a pre-existing condition, then the employer carrier can apportion medical expenses. This is the apportionment statute that went into effect on October 1st, 2003. Prior to the amendment, medical benefits were not apportionable, at least until prior or earlier than 1965. Now, in this particular case, Dr. Gerber, claimant's authorized neurosurgeon, recommended claimant undergo an L3 through 5 laminectomy with L4-5 pedicle screw fixation. Dr. Gerber did opine that 40% of claimant's need for medical treatment was related to claimant's pre-existing condition, such as degeneration and canal stenosis, and 60% was related to the accident. And the judge based his finding of apportionment on Dr. Gerber's opinions. However, his opinion does not support support apportionment under the statute. First of all, the judge found that the accident was not an aggravation of a pre-existing condition. So that throws that portion of the apportionment statute out. The judge did find that there was a merger, but there is no evidence of a merger in this case. Merger is defined in the statute. It's defined as the combining of a pre-existing permanent impairment or disability with a subsequent compensable permanent impairment or disability, which, when the effects of both are considered together, result in a permanent impairment or disability rating which is greater than the sum of the two impairment or disability ratings when each impairment or disability is considered individually.
Seems like you use the word merger almost generically there.
Almost as what, Your Honor?
Generically. Like the JCC almost used the term generically rather than as a term of art in the statute.
I think so, because the cases clearly state merger does not occur when you add an impairment from a pre-existing condition to an impairment after the accident and come up to one total. It's got to be greater than that. And there's no evidence in this record whatever that that occurred.
I mean, as I recall, the evidence is simply that 60% is attributable to some previous condition.
40% to a previous condition.
And that's it. There's no medical testimony as to what that condition is, as I recall.
Well, that condition is probably the pre-existing degenerative condition, right, and stenosis that the MRI showed. But there's no evidence that it aggravated that condition, or at least the judge found that it didn't aggravate that condition. And there's no evidence of the merger because there's no evidence that the accident and the pre-existing condition combined to create a greater permanent impairment than the individual two added together.
Now, counsel, make sure I understand it. The JCC expressly found that there was no aggravation, or found that rather than aggravation, he found there was a merger?
Well, he says, page 7 of the order, the initial consideration is whether claimant's present need for medical care in the form of the surgery recommended by Dr. Gerber is the result of an aggravation or acceleration of a pre-existing disease or condition, or is the result of a merger with a pre-existing condition. And then he goes on to say, Dr. Gerber's medical records are the only ones. Then he says, the only conceivable reading of Dr. Gerber's opinions is that the present need for treatment in the form of the surgery he recommended in August 2009 is the result of a merger of the pre-existing disease and conditions he diagnosed and the effects of the accident.
So you infer from that that he found that there was no aggravation.
Yes,
He found only that there was a merger.
Yes, sir.
Okay. So the reason for my question is, it seems to me that the record might support a finding of an aggravation, and if that's the case, why shouldn't we affirm on a tipsy coachman theory?
Because he's basing his order strictly on a merger. And there's no cross appeal. There's no appeal that says he should have found there was an aggravation of a pre-existing condition. In fact, they also, in their brief, they don't really argue against the fact that there's no competent substantial evidence to support a merger. So we submit that there's no basis in this case for apportionment. Now, my next argument is if there is apportionment, then we submit that the carrier should still pay 100% of the medical treatment under the hindrance to recovery doctrine. Because the doctor testified that he can't do surgery on 60% of the condition. And the hindrance to recovery doctrine provides that the carrier has to pay medical treatment for a condition not shown to be causally related to compensable injury if one of the primary purposes of treatment is also removal of a hindrance to recovery of the compensable accident.
Was that argument made to the JCC?
No, it actually is not. No, ma'am, not in that form. It wasn't. Although the claimant's attorney did request that the carrier pay 100% of the medical benefits.
So can we consider that argument now?
Well, I hope so. But I really, quite frankly, I don't think you even need to get to that, because I think the first point is pretty solid. I really do. The judge didn't find it based on an aggravation, and there's no evidence whatever of a merger. And those are the only two conditions under which the apportionment statute applies. My third argument is, if the court rejects all of those, is that the apportionment portion of 440.15.5b is unconstitutional as it denies claimants access to the courts, Article 1, Section 21. And
is that along the lines of Judge Webster's concurring opinion?
I defer to Judge Webster's dissenting opinion, but I mean
concurring.
Concurring opinion. I'm sorry. But I mean, the point is, I think the legislature's just going too far here. Every case that I could find where constitutionality was an issue, the court always says that the statute's upheld on constitutionality because of full medical benefits. They cite the Aguilera case where it says minimum or some benefits or something to that effect, but Aguilera had nothing to do with the constitutionality of the statute. I mean, here, I think by requiring the claimant, now this claimant, for example, had no prior problems with her low back, no disability, no nothing. And if she's now required to pay 40% of a very substantial low back surgery, as a practical matter, and as Judge Webster pointed out, many of these claimants are not going to be able to get the medical treatment. They don't have the 40%. And this goes against the purpose of the workers' compensation statute. It goes against the legislative intent to try to get these people back to work early and get them medical treatment. It's going to delay their getting back to work because they're not.
Of course, if we agree with you on issue 1, we won't get to that.
If you agree with me on issue 1, we don't need to get to that. And I'll reserve the rest of my time for rebuttal. Thank you.
Good afternoon. My name is Russell Young. I represent Gevity HR and Chartise Insurance Company. May it please the court. The judge of compensation claims in this case did find, with uncontroverted evidence, that the employer carrier should only pay for 60% of future medical treatment and apportion out the 40% that was attributed, and that word attributed is kind of important here, to the pre-existing condition. There is competent substantial evidence to support the judge's findings. As indicated, Dr. Gerber is the only medical testimony that was offered. In his opinion, the judge found attributed, and again I use the word attributed because it's in the statute, 40% of the need for treatment and the impermanent impairment rating to the pre-existing condition.
Well, can there be a an allocation like this without a finding of a merger or an aggravation?
Actually, I think there can. And the reason I say that is in the Staffmark case, which was decided not too long ago, this court set out a way of reading the statute 440.15.5b. And it said that 440.15.5b actually has 3 separate and distinct clauses. And in that case in Staffmark, if you look at the statement and the way it was laid out, it said that sentence 1 or clause 1 had to do with the apportionment of temporary benefits. Sentence 2 or clause 2 had to do with the apportionment of permanent indemnity benefits. And sentence 3 or clause 3 had to do with the apportionment of medical benefits. In this case, the only claim that was filed was for a payment of 100% of medical benefits. Therefore, we need only concern ourselves with sentence 3 of the statute 440.15.5b. Sentence 3 has no requisite that you have an apportionment, an aggravation, or a merger. All sentence 3 says is that you have to have a pre-existing condition and medical testimony that some portion of that pre-existing condition is attributed to, or some portion of the need for medical care is attributed to the pre-existing condition. In this case, again, the only medical testimony was Dr. Gerber, who did, in fact, attribute 40% of the need for medical treatment to a pre-existing condition. So to answer your question, yes, I do believe that you can have an apportionment without the necessary or prerequisite finding of an aggravation, acceleration, or a merger. In addition, this court found in Staffmark that even if a judge makes the right decision for the wrong reason, his decision should be affirmed. In this case, if the court finds that there does need to be an aggravation, acceleration, or a merger of a pre-existing condition with the current need for medical treatment, the judge's order should be affirmed because, as stated, Staffmark says when the trial court reached the right decision for the wrong reason, that decision will be upheld. Dr. Gerber, in his report, which is part of the record, volume 1, page 114, is a 5/23/2007 report, discusses the pre-existing conditions and the current need for surgery and what the surgery is going to have to deal with. And here's what he said. If she were to have surgery, it would need to take into account the overlying scoliosis, the L5-S1 retrololesthesis, the L4-5 spondylolesthesis, and the L3-4 stenosis. He goes on to say she may well require some degree of correction for the scoliosis. And here's the most important part, he said. Most of these findings certainly predated her work injury, but were relatively asymptomatic until such time as she had the accident. His words, he didn't use the magic words, he didn't say aggravation, acceleration, or merger, but what he did say was the same thing. He said that she had pre-existing conditions, that they were asymptomatic until the time of the accident, and that the surgery was going to have to deal with both the accidental injury and the pre-existing conditions. So one can only infer from his statements that there was, in fact, an aggravation or acceleration of the pre-existing conditions. Claimant states in her argument that we've...
Are you conceding that the definition of merger, that the evidence here does not support a finding based on the definition of merger in the statute?
I am hesitant to concede anything, but I'm constrained to do so. And the reason I say that, again, is just...
I appreciate your professional candor.
The statute and the way it's defined, there is no evidence here that the sum of the two impairment ratings would be greater than just adding them together. So, yes, I would have to concede that. However, again, I don't think that's dispositive of the question.
Do you think that judge's findings about the surgery having to address both causes, both pre-existing and the current condition, and the fact that it's implicit, if not explicit, allows us to affirm?
I do.
That's finding essentially an acceleration.
I think just based on the record itself, there is an acceleration that's evident, and it was the only evidence that the judge had to rely on. I think your point earlier in the question was that the judge seemed to use merger as a general term and not a term of art is probably accurate. Unfortunately, we did not file a motion for the judge to change the order to correct it in time. So but the fact remains that there is, the only evidence is...
Yeah, your argument is the only medical evidence here is a pre-existing condition of spondylosis, the accident, and the additional 60% caused by that. It has to be an acceleration.
Absolutely. Either an acceleration or an aggravation, whichever the case may be, but it has to be one of those two because Dr. Gerber tied them together so much in his reports and even in his deposition, but primarily in his reports when he talked about how the surgery was going to have to address each one and that the majority of those were pre-existing and were asymptomatic prior to the accident, so the accident had to cause an acceleration or aggravation. Moving on to the hindrance to recovery theory, we cited DeBrill's Florida Work Comp Handbook for the premise that the hindrance to recovery theory had been written out of the statute.
And you don't think it was preserved, do you?
Pardon?
Do you think it was preserved?
I think based on this case that Mr. McKay brought, Gallagher-Bassett versus Mathis, I think in certain circumstances it is preserved. However, in that case, Gallagher-Bassett versus Mathis, the portion that never came up as an issue.
No, I mean, do you think the claimant preserved the argument of the hindrance to recovery theory?
In the trial court, no, I do not, because it was never argued, it was never brought up. So in that regard, it should be done away with also. Finally, just briefly for the constitutional challenge, this court described in the Kluger case that an access to courts argument only exists if there's a complete abolition of a right. And under the workers' compensation statute, there is no abolition of the right to medical treatment. Now, certainly, there is a decrease in the right to medical treatment under the workers' compensation statute, particularly 440.15.5b, which we're here talking about today, in that if the accident's the major contributing cause, but not 100% of the cause, the employer carrier is told to apportion out that part of the medical treatment which is associated with the pre-existing condition. And that's exactly what we did in this case. So in Kluger, the court said that there is no access to court challenge unless there's a complete abolition, and that's not what happened in this case. There's a 40% reduction of benefits, not a complete abolition of the benefit. Excuse me. In addition...
So let's take Judge Webster's concurring opinion in a hypothetical. Let's assume that there is evidence that a particular claimant does not have the economic resources or the health insurance coverage to pay for the 40% of the medical bill. Isn't, in effect, the apportionment a denial in that case?
It's a denial of... It's not a denial of the medical benefit. It is a means of paying for the medical benefit. And I would submit to the court that in many, many cases, the employer carrier may go ahead and pay for the other 40%. And the reason they might do that is, and these are policy arguments, but the reason they might do that is that if an employee can't go back to work, the employer carrier has to continue to pay them for up to 104 weeks, and then after that, if they can't go back to work, they may have to pay them for life under permanent total disability benefits. So there's a motivation, in many cases, for the employer carrier to go ahead and pay it anyway. In this case, there was not at this time. This lady still continues to work. She's working full-time, and that's in the record. She testified to that in the trial and in her deposition. So I don't think it's a total abolition of the right to medical care just because there's an apportionment of the benefit. Finally, on the constitutional argument, I think this court dealt with the constitutional argument in the major case, which I cited, 46 Southern 2nd. Actually, I think it's Southern 3rd, 121. And basically, the court said access to the courts is premature until a claimant attempts to file an action against the employer carrier in civil court, and the employer carrier then asserts the workers' comp immunity defense. And in this case, that's not happened. So, again, based on the major case, I would say that this is a premature argument. Apportionment, whether we like it or not, exists in the statute. It is. And let me back up to that. Even if the court were to find that there's some constitutional issues here, there was there was a compelling interest that the state had and the legislature had in passing this statute. And that compelling interest was that around 2002, 2003, before the statute was written, there was at least perceived in the state of Florida that the employer carrier could not afford workers' compensation insurance coverage any longer. The statute was rewritten. Certainly, apportionment was a big part of it, along with major contributing cause, a change in permanent total disability benefits, and numerous other changes in the statute, which the legislature perceived would reduce the cost of workers' compensation to the employers of the great state of Florida. And it worked. From 2003 until 2010, the average workers' compensation rate was reduced by 65%, meaning that in 2010, the employer only paid 35% of the rate that they were paying for workers' compensation benefits that they paid back in 2003. So there was a compelling public, or an overpowering public necessity, an alternative method to meet this necessity is really not available without the change of the law. And I think the legislature did what they were supposed to, or what they needed to do, to keep people working in the state of Florida and keep businesses prospering in the state of Florida without the burden of over-costly workers' compensation premiums. And I will end with that. Thank you.
Getting back to this claimant working, I mean, yeah, she's working light duty because she has to. She's in pain. And
can you address the argument that the judge's comments or the judge's statements about here the surgery will have to address both the pre-existing condition and the current condition, and we should find implicit in that and that's CSE to support a finding of aggravation or acceleration?
Yes, I will. And to answer one of the questions is apportionment does only apply if there is aggravation or acceleration or a merger, because that's what the statute says. And I don't see how the judge's order can be read that he implicitly found aggravation of a pre-existing condition, because he states the initial consideration is whether the present need is the result of an aggravation or acceleration of pre-existing disease or condition, or is the result of a merger with a pre-existing condition. So he's aware that these are the two situations where it can occur. And what does he find? He finds there was a merger. He does not find there was aggravation or acceleration of a pre-existing condition.
But in an ideal case, or I mean, in a case in which the judge addresses both factors, you know, sometimes the judge will say, and if that's not the case, then I'm going to look at these factors. What more evidence would have been required to have found aggravation or acceleration?
Maybe somebody needed to ask the doctor, was this pre-existing asymptomatic condition aggravated or accelerated by this lady's accident? No one asked that question that I can recall. The doctor didn't testify to that. I would think you would need medical testimony to that effect.
And I'm not necessarily disagreeing with you. I'm just asking, so when the doctor testifies that 40% of the claimant's overall injury is attributable to a pre-existing condition, that is the medical testimony your opposing counsel referred to, how is that not an acceleration or an aggravation, factually speaking? I may be out of the realm of what we can discuss without that question being asked from a medical expert. But.
Well, this lady wasn't rated by anybody before the accident, but perhaps she had a 40, well, let's see, he said the overall impairment rating was 13%, 40 of which was pre-existing, so that comes out to be, I don't know, say 5%. Okay. Maybe this lady had a 5% permanent impairment before the accident ever happened. I mean, I don't know. Maybe the accident didn't aggravate or accelerate it. It somehow stayed exactly where it was, and the accident added on top of it. So I really don't see how there can be an implicit finding. And believe me, I see comp orders sometimes where judges will go, I also find in addition to a merger, there was a pre-existing or aggravation of a pre-existing condition. And they just give reason after reason to support their opinion. But in this case, that wasn't done. The judge.
Do you think if he had said that in this case, the JCC, would this have been sufficient competent substantial evidence. That's all he said. Was, well, I also am going to look at it for aggravation and acceleration, and I find based on the pre-existing condition that it was accelerated.
I don't know. There might have been. I mean, to be honest, I'd want to reread the doctor's deposition again and see if I thought so. But he doesn't make that finding here, and I just don't see how it can be implicitly found when he considers the two and finds it's only a merger. I really think that's a leap. And I think if they wanted to bring that issue before the court, it should have been by a cross appeal saying the judge erred in not finding it was an aggravation of a pre-existing condition. Thank you.